Friends, after discussing the theoretical underpinnings of the space law in part one of this lecture, let me now move forward with the practical aspects in this part two. First of all, state sovereignty and the property rights in the outer space and celestial bodies. Article 2 of the Outer Space Treaty, as I have already discussed, clearly prohibits national appropriation by claim of sovereignty, use or occupation, or by any other means. And since the beginning of the space activities, it was very clear that the outer space cannot be subject to the sovereignty regime. Rather, it should be more in terms of the freedom regime. But unfortunately, there are many instances in the history wherein this principle of absence of sovereignty in the outer space and celestial bodies has been threatened. First of all, when the Soviet Union had the lunar landing, initial landing, at that particular point of time, a question was whether the Soviet Union is going to claim any sovereignty over there. Subsequently, in 1969, when the United States had its first human landing on the moon, once again the same issues cropped up, especially because the United States flag was implanted by Neil Armstrong on the moon. So therefore, it was the question was whether this is an indication of assertion of sovereignty by the United States. Both the USSR and the United States rejected such kind of a possibility. USSR, on the one hand, declared that it is not going to claim any kind of sovereignty. On the other hand, the United States passed a separate legislation, that is the law on the implantation of the US flag. And it made very clear in this legislation that this implantation is just a symbolic gesture of their national pride and nothing more than that. They've achieved the landing on the moon, that's it. And nothing more is reflected out of the implanting of the flag. And they are not going to claim any sovereignty or nationally appropriate the moon, contrary to Article 2 of the Outer Space Treaty. This belief, the strong belief of the spacefaring nations, had got a threat in 1976 with what is called as Bogota Declaration. In Bogota Declaration, 8 of the equatorial states, the smaller states who do not have much technology, space technology, especially at that particular point of time, they met and claimed sovereignty over the geostationary orbit, which is almost 35,800 kilometers above the Earth's equator. They claimed sovereignty over an orbit which is 35,800 kilometers above the Earth's surface. This is primarily because the geostationary orbit is one of the most useful Earth orbit. The geostationary orbit rotates proportionate to kind of the Earth's speed, and consequently, a point in the geostationary orbit as against a point on the Earth's surface would always be in the same angle. The angle would be same. If a satellite is placed in the geostationary orbit, then there is no requirement of maneuvering the receivers for the purpose of receiving the signal. The angle is always constant. So therefore, there is no requirement of changing the direction of the receivers, and it helps in reducing the operating cost very much. Moreover, it is also more useful. The placing of the satellite in the geostationary orbit is more useful in terms of the mapping of the entire Earth. Precisely because of that reason, every country wants slots in the geostationary orbit. These equatorial states argued that most of them are yet to develop their technology. But on the other hand, the developed countries who have developed the technology, they are taking a lot of slots in the geostationary orbit. Therefore, by the time the developing countries develop their technology, no slot would be available to them in the geostationary orbit. This is why they argued that the portions of the geostationary orbit which are above their territory should belong to them. They should have sovereignty over it. And any state which would like to place the satellite in those portions need to take their permission. The remaining portions of the geostationary orbit, which may be over the high seas, they should be declared as the common heritage of mankind. So this is what they basically proclaimed in the Bogota Declaration of 1976. And subsequently, they have also placed this declaration before the UN Corpus. But unfortunately for them, none of the states have supported this proclamation. They all argued that this is contrary to Article 2 of the Outer Space Treaty. It would amount to national appropriation or claim of sovereignty, which is not permissible under Article 2 of the Outer Space Treaty. But whatever it may be, the Bogota Declaration is one of those instances which tried to threaten the very fundamental principle of absence of sovereignty in the outer space and celestial bodies. Therefore, we should be careful in looking into these kind of the practices or these kind of actually the declarations, whatever the states are basically putting forward. The other aspect which I would like to point out here is about the property rights in the outer space and celestial bodies. When I speak about the property rights here, I'm speaking about the claim of the rights by the individuals. Sovereignty, which I pointed out earlier, is that the state claims. But here I'm speaking about the property rights which might be claimed by the individuals. Over the period of time, there are many individuals who have also claimed the property rights over the outer space or more particularly over the celestial bodies. We have a person by name Dennis Hope who has claimed the rights over the moon and other celestial bodies. He also says that he has registered his claim in San Francisco County Seat Registry, and he is also selling the parts of the moon and other celestial bodies to different people across the globe. In fact, he has already sold it to several million people across the globe. There are other people like the Gregory Nimitz, who has claimed the property right over an asteroid. Subsequently, we have a person by name Sylvia Langevin, who has claimed the property rights over different celestial bodies and even moved to the Superior Court of Quebec for recognition of his rights over the celestial bodies, so on and so forth. But we should keep in mind that all these claims of the property rights have emerged due to the misinterpretation of Article 2 of the Outer Space Treaty. All of them argue that Article 2 prohibits only the national appropriation, but it does not prohibit any individual appropriation. This is again a misinterpretation we have already discussed in the part 1, because when we speak about the prohibition of national appropriation under Article 2, Article 2 also prohibits the individual appropriation within the ambit of time. The drafters of the Outer Space Treaty never intended to allow the individual appropriation by only prohibiting the state appropriation. That's why all these things are something not justifiable under Article 2 of the Outer Space Treaty. Now, the next aspect is about the space habitation. With the shortage of space as well as the resources on the Earth, plans are being developed for the habitation in the outer space or more particularly in the celestial bodies. The pioneer space agencies like NASA, European Space Agency, all of them are involved in this kind of work. And at the same point of time, even the private space actors have started thinking in terms of human habitation in the outer space and celestial bodies. And this also brings forward several legal issues under the space treaties. First of all, one of the crucial questions is again under Article 2 of the Outer Space Treaty. Wouldn't this permanent habitation in the celestial bodies result in contravention of Article 2, wherein the national appropriation or even the private appropriation is prohibited? These people who would be occupying therein would be occupying on a permanent basis. So consequently, those regions which are occupied by the celestial inhabitants cannot be subject to the access by others. The free access of others would not be available. So by virtue of that, it would amount in a way to appropriation prohibited under Article 2. At the same point of time, under Article 1 of the Outer Space Treaty, there is also a freedom of exploration, use, and scientific investigation in all parts of the outer space and celestial bodies for everyone. That would also be hindered with the permanent human habitation on the moon and other celestial bodies. So that's why the questions have arisen regarding the human settlements, especially in terms of the appropriation of the celestial bodies and their resources. Second, there are also questions with respect to the mining of the resources in the celestial bodies. Once these people inhabit the celestial bodies, there would also be the possibility of these people going for mining of the resources available on the moon and other celestial bodies. They would certainly claim certain rights over those resources. Wouldn't that go contrary to the common rights principles which have been developed in the space treaties? Is also a debatable issue, especially in light of the principles like the province of all mankind and the common rights of mankind. Third, with the human habitation in the outer space and celestial bodies, there would be more problems in terms of the environmental protection. Outer space and celestial bodies have got environment which is more fragile than the earthly environment. Therefore, any damage, whatever is caused in the outer space and celestial bodies, would be having a long-standing effect. And even some of the things which may be considered as biodegradable in the Earth would not be degraded in the outer space and celestial bodies due to the lesser density of the atmosphere. So all these things bring forward crucial questions regarding the protection of environment in the outer space and the celestial bodies. And finally, one more important aspect about the human habitation is that what would be the law governing the day-to-day activities of these people who would be inhabiting the outer space and celestial bodies, especially their activities or maybe their interrelationships in terms of marriage or maybe in terms of the divorce, adoption, succession, so on and so forth. All these things, how exactly they need to be regulated. As of now, there is no separate law, and application of the earthly law to these inhabitants in the outer space and celestial bodies would also bring forward the question, which law has to be made applicable? Should it be on the basis of nationality of those individuals who go therein? Should it be on the basis of actually the registration of the object? Whichever state has registered the object, their law should be made applicable. Or is there any other way in which any law can be made applicable for the purpose of regulating the day-to-day activities or the interrelationship between the celestial inhabitants is a debatable issue regarding the space habitation. So therefore, space habitation has to be well thought of before implementing this plan. The space tourism. Starting from Dennis Tito, who became the first space tourist in 2001, there have been 7 more tourists who have entered into the outer space, especially they have visited the International Space Station. After 2009, the space tourism has not been carried on, but in fact, this is done for the purpose of developing further the technology. It's not for the purpose of putting an end to the space tourism, but to develop further the technology for the purpose of having more efficient space tourism. We can find that there are many private companies like, say, SpaceX, Virgin Galactic, then Armadillo Corporation, so many, or Blue Origin, so many other companies who have all come into the picture for the purpose of carrying on the space tourism. But the space tourism once again brings forward crucial questions under the space law. And one of the very, very significant questions in terms of this is that what law should be applicable with respect to the space tourism? Should it be aviation law or should it be space law? Especially because most of the space tourism activities involve the vehicles which are aerospace vehicles. They would be flying in the atmosphere like an aircraft, and they're also capable of orbiting around the Earth just like the space object. They are the aerospace vehicles. They have both the features of the aircraft as well as the space object. So questions should be, where should they be registered? Should they be registered under the aviation law? Should they be registered under the space law? Who should be licensed? In what method it should be licensed? Should it be under the aviation laws procedure or should it be under the space laws the procedure? How exactly it has to be licensed? Who should be bearing the liability in the circumstances of any damage caused out of the space tourism activities? In fact, aviation law and space law are quite contrary to each other in terms of the fixation of liability. So precisely because of that reason, multiple questions arise in terms of the applicable law itself. Therefore, the space tourism, before we actually go for more and more space tourism, we have to ensure that what is the specific law which should be made applicable to space tourism activities. Added to that, another important aspect which might arise under the space law is that whether the space tourists are entitled to the same kind of privileges as has been enjoyed by the astronauts. Because as we have discussed in part 1, by virtue of the principle of astronauts as envoys of the mankind, the astronauts and the personnel who assist the astronaut enjoy certain privileges during the emergency. There is a requirement of emergency assistance, and the astronauts and the personnel need to be returned back to the launching authority under the rescue agreement. We have a separate agreement with respect to this. But all those things come out of the principle that the astronauts or the personnel are doing something for the common good. That's why a third state has got an obligation to ensure that these astronauts or the personnel are rescued and returned back to the launching authority, even though there is no requirement for the cost reimbursement. But whether the same principle is also applicable to the space tourists who don't go to the outer space for doing anything for the common good, but for their own personal enjoyment, is really a debatable issue. So these are the questions which need to be pondered upon before actually we go for more and more space tourism activities. Next issue is in terms of the protection of space environment. With the increased space activities, we are incurring the cost in two terms. Of course, on the one hand, investments in the space activities is huge. Maybe multi-billion dollars investments go in the space activities. On the other hand, we are also having cost in terms of the environmental degradation in the outer space and even the celestial bodies. We look into the current scenario regarding the space debris, it is really scary. Most of the satellites have been left out in the outer space after it has become defunct. Some of them have even fragmented. A lot of space debris is revolving around the Earth. So by virtue of all these things, it is very clear that our future activities in the outer space itself is threatened by the environmental pollution in outer space. With a lot of debris, there is more risk of collision. So penetrating this debris cloud and then launching a satellite into the outer space itself becomes a real problem. So this is the very reason why protection of the outer space environment is very, very important. There are multiple sources of the space pollution. It may be space debris. It may be the chemical effluents, the chemical substances which may be released during the launch or subsequently. It may be biological contaminants, certain things or organisms which may go from Earth to the outer space, or something coming from the outer space to the Earth and causing some kind of a mutation or the changes in the environment. And even the fourth major source of the space pollution is the radioactive pollutants. Some of the space objects do carry the nuclear power sources on board them. So consequently, there might be possibility of the radiation emission or even the interface of the signals and all causing a lot of the problems. So there are multiple sources of the space pollution, and scientific community has devised several plans, but unfortunately, they have not been very much successful in mitigating the environmental damage in outer space and celestial bodies. In terms of law, we can find only one provision in the Outer Space Treaty in the form of Article 9 of the Outer Space Treaty. And Article 9, the major portion of Article 9, says that in carrying on the activities in the outer space and celestial bodies, there shall not be any harmful contamination of the outer space and adverse changes in the Earth environment. Harmful contamination in the outer space and adverse changes in the Earth environment is prohibited under Article 9. But unfortunately, even if we look generally into these phrases, it is very clear that the harmful contamination is a much, much narrower term when compared to the adverse changes. Therefore, Article 9 focuses more in terms of preventing the environmental pollution in the Earth rather than the environmental pollution in the outer space. It is very weak in terms of preventing the environmental pollution in the outer space. And even some of the scholars have argued that the debris creation is also not prohibited under Article 9 because it does not amount to harmful contamination. Harmful contamination is a very, very narrow term. So by virtue of that, the Article 9 of the Outer Space Treaty seems to be one of the weakest limbs of the Outer Space Treaty in terms of the protecting the space environment. When compared to Article 9 of the Outer Space Treaty, Article 7 of the Moon Agreement is an improved version in terms of protecting the celestial environment. Unfortunately, the Moon Agreement has been signed and ratified only by a limited number of countries. And also, the Moon Agreement is applicable only to the Moon and to the celestial bodies, not to the outer space or maybe the Earth orbit. So precisely because of that reason, the Article 7 of the Outer Space Treaty would not help in any way for the purpose of mitigating the environmental damage in the Earth orbit. So because of all these reasons, we need to have a stronger provision in terms of the environmental protection in the outer space and the celestial bodies. Next issue is the military aspects in the outer space. Since the beginning of the space, it was very clear that the outer space is going to be used for some military advantage. Both the United States and the USSR invested heavily for the purpose of the development of the space technology in the Cold War region, especially because of the reason that they wanted to use the outer space for military advantage. And this was known to the international community. And by virtue of that itself, the UN General Assembly has established the UN COPUS, United Nations Committee on Peaceful Uses of the Outer Space. Plus, also the UN General Assembly has passed a series of resolutions for the purpose of ensuring that the outer space is used for peaceful purposes and not for military purposes. Finally, when the Outer Space Treaty was drafted, Article 4 was incorporated for the purpose of preventing the military uses. In fact, there are other indirect provisions also in the Outer Space Treaty, like Article 1 of the Outer Space Treaty, which says that the outer space and celestial bodies should be used for everyone's benefit and interest. So military activities might go contrary to everyone's interest and benefit. Then Article 3 speaks about application of international law, including the UN Charter, while carrying on activities in outer space and celestial bodies. And if we look into the UN Charter, it also speaks about maintenance of international peace and security, and to a greater extent, discarding the armaments. Then we also have other provisions regarding the transparency building and all, which may all, in a way, contribute indirectly to prevent the militarization of the outer space. But the only direct provision on the military activities has been Article 4 of the Outer Space Treaty. But unfortunately, Article 4 has got many loopholes in terms of interpretation. While it has got 2 paragraphs, the first paragraph prohibits the placement or orbiting of nuclear weapons or any other kinds of weapons of mass destruction. Nuclear weapons or any other kinds of weapons of mass destruction. Unfortunately, this only speaks about nuclear weapons or any other kinds of weapons of mass destruction. There is no clear-cut prohibition on conventional weapons in the outer space. Moreover, it also speaks only about placing or orbiting of the nuclear weapons or weapons of mass destruction. It does not impose a prohibition on testing of the weapons in the outer space. That is again another limitation of the first paragraph of Article 4. And if we look into the second paragraph of Article 4, it clearly states in the beginning itself that the moon and other celestial bodies shall be exclusively used for the peaceful purposes. Of course, seems to be very important provision. But unfortunately, when it is mentioning about the peaceful users, about the moon and other celestial bodies, it fails to mention about the outer space. So therefore, there is every possibility of outer space being used for those purposes which are not peaceful in nature, which is very absurd. We are very much concerned about the outer space being not being used for the military purposes, but unfortunately, the second paragraph, when it prohibits or when it speaks about peaceful users, it says only about the moon and other celestial bodies. Over and above this, the term peaceful users has not been defined anywhere. And by virtue of this, the states are interpreting the peaceful users in their own way. While initially some states advocated that peaceful means non-military, there should not be any military activities in outer space or celestial bodies, states like United States have started arguing that the peaceful should be non-aggressive. That means military activities can be permissible, but it need to be only non-aggressive. It should not be aggressive military activities, only defensive or non-aggressive. But unfortunately, over the period of time, if you look into the state practices, most of the states have practically adopted non-aggressive use of the outer space. They have gone for militarization. A lot of military activities are happening, maybe direct or indirect. Like the United States has gone ahead with actually the Star War program, the Strategic Defense Initiative. Similarly, the other countries like say China, of course, US and USSR also earlier, they have also tested the anti-satellite missiles. India has also joined this list by testing its own anti-satellite missiles. All these things indicate that different military activities are going on in the outer space. In all probability, kind of a dangerous trend, and we are not very sure where exactly this is going to end up. That is why Article 4 of the Outer Space Treaty needs a kind of an improvisation. And even though Article 3 of the Moon Agreement, it also speaks about the demilitarization, it's a stronger provision. It has again got the limitations, as I have just discussed before. So we need to have a stronger regime in terms of preventing the weaponization as well as the militarization in the outer space and the celestial body. Significant aspect, practical aspect, is the intellectual property issues. With the development of International Space Station, it is very clear that the inventions are going to be conducted in these stations. Especially the inventions in the outer space has got its own advantages. The scholars predict that so many pharmaceutical breakthroughs is possible in the outer space due to the near zero gravity atmosphere therein. More pure forms of actually certain chemical compounds can be created, which should be helpful in different kind of other pharmaceutical studies and the research. That's why inventions are going to happen more and more in the outer space and maybe in the future on the celestial bodies. Now, one of the most significant IP issues that comes forward in the outer space activities is the patents regime, inventions and granting of the patents. In terms of the patents regime, we should first keep in mind that there is no international patent law. Patent laws are all municipal in nature, they are diversified and applicable in their respective states, whatever has been enacted. Only thing is that the TRIPS speaks about the minimum standard that need to be maintained. But apart from that, the laws governing the patents is completely domestic in nature. In the international level, especially under the space activities, there are two questions which crop up regarding the patents. First is, can there be granting of patents for an invention which is conducted in the outer space or celestial bodies? This is crucial because patent is a monopoly right. It's a monopoly right granted to the inventor. But on the contrary, if you look into the space law has always advocated for common rights. Everyone shall have the rights in the outer space, celestial bodies, resources therein, etc., etc. Now, if a particular inventor uses a resource in the moon or other celestial bodies, some common resource is being used for a product, and ultimately he is claiming a product patent over that particular product. Can this be granted? Especially because he has used a common resource for the purpose of coming up with an end product, and now he is claiming a monopoly right over the end product, contrary to the interest of actually everyone. So would it be possible? Itself is a debatable issue, but most of the scholars do believe that it is required to provide. Otherwise, nobody is going to invest in the space inventions. The huge investments which are required for the space inventions would not be available. So that is the very reason why the argument is that the patent rights need to be granted to the inventors in outer space. However, some scholars argue that compulsory licensing, some sort of a compulsory licensing on fair and equitable grounds would be something which can be implemented for the purpose of ensuring that the benefits of the space invention goes for everyone. Now, whatever it may be, the very next question which crops up about the granting of patent is, how should it be granted? Should it be granted on the basis of the first to file system or first to invent system, which was prevailing earlier? Now there is a first inventor to file system, which is prevailing in the United States. Should it be on first to file or first inventor to file? Of course, there is not much difference now, first to file and first inventor to file system. But what is more important is that in these systems, whoever is actually having the document which shows that a particular kind of an invention has been done, and once they place it before the patent office grants the patent to the concerned person. This might be problematic in the space inventions especially because whatever activities are happening in the outer space would be monitored from the ground segment. There are some people in the ground segment who have got access to this. They would be knowing about how exactly an invention is carried on in the outer space or maybe in the International Space Station. And ultimately, a person from the ground station might go to the patent office immediately after actually completion of the invention and file for a patent. Going by the first to file, they would be able to have the patent in their favor, even though they are not inventors. The inventors are the concerned astronauts who are still in the outer space. So that's why it might create certain problems, certain issues in terms of the granting of the patents. Now, on the one hand, while we have the problems regarding the granting of patents, on the other hand, we have got more peculiar problems in terms of infringement of the patents in the outer space and celestial bodies. When I speak about infringement, I am speaking about an invention which has been patented on the Earth, but an astronaut goes to the outer space or maybe in the celestial bodies and infringes this invention. What law should be made applicable? Who should be having the jurisdiction? It becomes very debatable. In terms of jurisdiction, I have already discussed in the part 1 of this lecture, Article 8 of the Outer Space Treaty speaks about two different kinds of jurisdiction. One is the quasi-territorial jurisdiction, another one is the personal jurisdiction. And unfortunately, there is no hierarchy created between the two. That's why the problem might arise that in a case wherein the astronaut has been launched from the space object of one country and he enters into the International Space Station belonging to the another country, then the question arises, who is going to exercise the jurisdiction? Both of them may contain jurisdiction, or both of them may point towards each other for the purpose of exercise of the jurisdiction. So jurisdictional problems would obviously be there by virtue of Article 8 of the Outer Space. Second issue is in terms of applicable law. Whose patent law should be made applicable for the purpose of dealing with the infringements? Should it be the law of the nationality of the infringer, or should it be the state of registration of the space object? Whose law should be made applicable for the purpose of dealing with the space infringement of the patents in the outer space? That is really a debatable issue. None of them provide any kind of a concrete solution. And as I've already pointed out, there is no international patent law. Municipal laws application is the only possible option, but we don't have the specific criteria for the purpose of applying any municipal patent law for the purpose of dealing with the infringement of patents in outer space and the celestial bodies. That's why we need to think laterally in terms of developing stronger patent regime as well for dealing with the inventions in the outer space and the celestial bodies. Now, the last thing which I would like to point out in terms of the practical significance of space law is the aspect of financing the private space activities. Space investments are huge. There are multi-billion dollars which are involved in terms of the space activities. The private space activities, multiple companies have come up of late, but all of them would require enormous amount of the finances. And this financing cannot be expected by these private companies within their own jurisdiction. One single country, within that, they might not be able to get all the finances for carrying on their multiple space activities. They might have to borrow the finances from different jurisdictions, the creditors from the different jurisdictions. But ultimately, the problem is that in a circumstance wherein these space companies or the debtors in terms of the financing, if they fail to pay back the money to the creditors, what law should be made applicable for the purpose of enforcing the right to the creditors? Especially in the space activities, what operates is something called as asset-based financing. That is, the space object for which the finances are taken itself is pledged as a collateral for the purpose of getting the finances. Because most of these private companies are not having any other thing to pledge as collateral for maybe a few $1 million or maybe a few $1 billion. They don't have assets, sufficient asset to pledge as collateral, just like in the traditional financing. Here, they have to pledge the satellite itself or the parts of the satellite itself for the purpose of getting the finances. That's why it is called as asset-based financing. Now, in the asset-based financing, one of the key features is that it is a non-possessory security interest which has been created in favor of the creditors. That means the space object, which is the collateral, would be in the position of the debtor, not in the position of the creditor. Because ultimately the debtor is going to use this object or the collateral. He would carry on the activities, and whatever profit he would get out of that, he would be using for paying back the debt, paying back the debt to the creditors. That's why it's a kind of a non-possessory security interest, which we can find it akin to that of hypothecation in the common law system. So debtors would be having the position and not the creditors. Creditors' right would accrue only when the debtor makes a default regarding the payment to the creditor. So it's a non-possessory security interest. Unfortunately, dealing with this non-possessory security interest is not uniform throughout the world. While the common law countries do recognize the non-possessory security interest, some of the civil law countries have got reservation on the non-possessory security interest. Some of them don't even recognize the non-possessory security interest, and some others might recognize in a very, very limited manner. Some kind of remedies are not available, self-help remedies are not provided. Like that, actually, there would be limited recognition of the non-possessory security interest in certain jurisdiction. So by virtue of that, it's very clear that there is a diversified regime regarding the financing and enforcement of the rights of the creditors in jurisdictions like the common law countries and the civil law countries. Now, in case of tangible movables, the space assets are nothing but the tangible movables. In case of tangible movables, if we look into the conflict of law principles, the law applicable is the lex situs. Any kind of a question which comes up before the court of law, applicable law would be the lex situs, or the law of the place wherein the object is found at the time of actually the transaction or at the time of the activity, like in this case, the default. By virtue of that, what happens is that if the debtor wants to defeat the interest of the creditor over the space object after the financing, he can play around very well. What the debtor can do is that debtor can commit the default at a point of time when the space object is in a country which does not recognize the non-possessory security interest. If there's a default, by virtue of the conflict of law principles or the so-called private international law, the law which would be applicable is the lex situs, that is the law of the place where the object is. And if that country is not recognizing the non-possessory security interest, the creditor's interest in the space asset is gone. Creditor cannot enforce his rights, especially because the applicable law is not recognizing this non-possessory security interest. That is why the creditors in the space financing are having the problem, and they don't have confidence much in terms of the space financing. By virtue of this, Unidruva, which is an agency for the purpose of unification of the private laws, it has worked in the direction of unifying the laws regarding the space financing. In fact, it worked primarily in a broader ambit of the mobile equipment. The mobile equipment in the sense those which move from one jurisdiction to another jurisdiction. Right? So those mobile equipment, with respect to them, Unidruva has tried to unify the financing laws. It had come up with a two-tier structure. One, a base convention, the Cape Town Convention, and second, in the second tier, area-specific protocols. The base convention codifies the fundamental principles which are governing all mobile equipment, different kind of mobile equipment, and the area-specific protocol are specific to certain areas. And currently, there are three major areas. One is the aircraft equipment. Regarding the financing, the aviation financing, they have a system, the base convention plus the aircraft protocol. Then second is the railway rolling stock, those parts of the railway which moves from one jurisdiction to another jurisdiction. So with respect to financing of them, also the convention on the mobile equipment and the protocol deal with it. And finally, the third major aspect is the space assets. With respect to the space assets, we have a separate space asset protocol. So this is a two-tier structure deals with the financing in the mobile equipment, including the space asset. There are different things which have been spelled out in the space asset protocol, base convention, as well as the space asset the protocol. Say there is a process of registration of the interest in the international registry, so that everyone can get to know about what is already existing interest. There are remedies available under the Unidruva system itself, so that even if the municipal laws do not recognize those remedies, the creditors can get remedy under the Unidruva system. Even in case of insolvency also, the creditors can get actually some kind of the remedies. That's how the Unidruva system tries to strengthen the confidence of creditors in the space financing. Not just the space financing, financing of other mobile equipments as well. But unfortunately, in the field of the space assets, the system has not come into operation. The space asset protocol has not been signed and ratified by any country, and consequently, the entire Unidruva system regarding the financing of the space asset has not come into existence till today. Even though Unidruva is still working in the direction of fine-tuning the entire treaty as well as the protocol regime, I think it would still take some time for the purpose of implementing a separate system at the international level. In the absence of such a system in the international level, now it is up to the states to build the confidence of the financiers for financing the private space activities. So states are also making some kind of a efforts at their municipal level, maybe in terms of the national legislation, or maybe in terms of actually giving some kind of assurance to the foreign creditors. By virtue of that, they're trying to get more and more investments in the space sector. But how far it would be successful is really debatable. In all probability, we need something in the international level for the purpose of ensuring that the confidence of the creditors in the financing would increase, and ultimately there would be more and more financing coming forth for the space area. So this is all with respect to the different practical aspects in the field of space activities. Of course, again, it's just a brief outlook of actually the practical significance of the space law, and nothing more than that. Thank you so much for your patience here.